You're listening to Stream of Conscience, Becket's Religious Liberty podcast. I'm Katie Geary.
And I'm Angela Wu Howard.
This episode is about what happens when the government decides your private property isn't, well, private.
The case we're talking about today is about property rights, eminent domain, something called the Takings Clause, and a bad precedent known as Williamson County.
What does it mean for the government to take your property? Is it legal? What can you do about it if it happens? And why would a religious liberty firm file a brief in a property case?
The short answer is because religious liberty is closely connected to other foundational rights, including the right to private property.
The long answer is a little more complicated, and it gives a, frankly, kind of head-spinning look at how our country's courts work. Let's get started. We talk about the First Amendment all the time around here, but today we're talking about the Fifth Amendment.
More specifically, we're talking about the very last line of the Fifth Amendment. Nor shall private property be taken for public use without just compensation.
Now, my gut reaction to that is, well, how about private property should never be taken for public use, period? But that's not really practicable in a functioning country. And to explain that, let's start with a concept in the law called eminent domain.
Eminent domain goes way back, historically. To help us out, we talked to David Bremer, senior attorney at Pacific Legal Foundation, PLF.
The concept of eminent domain is the concept that the sovereign, originally the king, and now in our democracy, the state, has the right and power to take private property for public use as long as it pays for it. So the example for eminent domain, the quintessential example is a road across your property. The government wants to build a road. There's nothing you can do as a property owner to stop the government from taking your property, but the government has its own condition, and that's that it must pay for it.
So despite my gut reaction, eminent domain actually makes sense.
Because there are certain things that we consent as a group of people. We cede certain powers to the government by consent to do things for our common good. And one of those powers is the right and the power to do public improvements that benefit everybody with the necessity of taking private property when it's needed to accomplish a road, a bridge, a park, because otherwise one person could hold out and say, no, I don't want to sell for anything. I don't care how much. If there's a voluntary system, you could stop necessary improvements. So it comes from the original monarchy system where the king could take your property in England and elsewhere and use it for something, but they had to pay you for it. So there's a condition on that power, but that power is part of what we've implicitly consented to by creating a government in the first place.
In theory, then, eminent domain is a strong but reasonable power for a government to wield. In practice, it's a power that's fairly easy for a government to abuse.
The limit put on the government is that it has to provide just compensation when it takes private property for public use. But where it gets kind of loose is in the definition of public use and in what counts as a taking.
What's happened is governments have started to take private property for other reasons.
That's Joe Davis, counsel at Becket.
Like taking it from one private person and then giving it to another private developer just to do something with it that's going to create more tax value for the government. So somebody's house might only be worth so much in property taxes to the government, but if somebody's going to develop it into a shopping center or something like that, they pay a lot more property taxes. So here you have financial incentives playing a very negative role in what the government is doing with its takings power, with the eminent domain power. And then you also have governments that are enacting laws that take away people's property rights, but they don't say we're exercising our eminent domain power. They just enact these laws, and they're takings in effect, but it's the government trying to get out of paying compensation when it affects people's property rights.
David Bremer and his firm are the ones who ended up taking the case we're discussing today, Nick v. Township of Scott, Pennsylvania. They took it all the way to the Supreme Court. Becket filed a friend of the court brief in the case.
We'll get to the details of that case in just a moment. Joe pointed out that sometimes the government takes private property, in effect, without calling it a taking. Sometimes they're not turning a space into anything in particular, but they just want to keep it open.
But what's controversial is in this situation where they zone you open space. And because they want to conserve an open space area that's been built out. And they say, we don't want any more building. We're just going to zone you open space. So you, property owner that own this last chunk of land, like I have 5 acres, you can't build anything because it's zoned open space. It's residential over there, whatever there, but we want some open space. So you're going to bear that burden for the public. That public wants some open area so that it can, scenic. And it doesn't say it's taking your property. It just does that. And then you have to sue and prove that it's a taking. So that's the part of the abuse that's more subtle, is when the government takes your property without explicitly taking it. So the Constitution protects you by guaranteeing your right to compensation when they take your property. But the trick is, what does that word take mean? So in the example of a road, pretty obvious they're taking something. It was yours, and now they're there. That's been, okay, but in my other example of open space, is that a taking? They didn't physically come and government agents and government trucks and confiscate that property. It's still yours, you still have title to it, but you can't do anything with it. Is that a taking?
Well, is it? How do you establish that the government took your land if it hasn't been turned over to someone or something else?
It turns out to be really difficult, but one woman did it in Nick V. Township of Scott, Pennsylvania. Rosemary Nick, a woman in her 70s who lives on 90 acres of farmland in Pennsylvania.
90 acres of private property, which she's lived on for 50 years. And the government, the town, a small town there, passed an ordinance which said that government inspectors or town inspectors have the right to go on any parcel of property in the township to look for the existence of cemeteries. And if they find what they think is a burial ground or a cemetery, then the public has access to it by regulation. Now, immediately when we say cemetery, we have this picture in our mind of what a cemetery is. And let me just get to that a little bit. In Pennsylvania, backyard burials are permitted. They've never been outlawed. So in Pennsylvania, you can bury Grandpa Joe under the old oak tree legally, and people have done that. So there are small grave sites going back 200, 300 years in Pennsylvania all over the place. And so a law like this, which was the first in the kind of the town, is pretty extraordinary to say that we're going to give anybody from New Jersey or wherever, kids, the right to walk on your private property to an area where we think there's some old gravestones.
Rose's property was fairly ordinary farmland.
So we're talking about 90 acres of land about 20 miles north of Scranton in Pennsylvania, in eastern Pennsylvania. It's a very quiet area, wooded. She's got her home on the land. There's another structure, another home she rents out, like a barn. She leases out a lot of her land for pumpkins and for people to farm pumpkins and stuff like that. There's nothing unusual or extraordinary about it. The only thing it's not extraordinary at all, but I guess it's to the town is that someone in the town thought that there is grave sites about 100 yards, I believe, maybe 300. I can't remember. I forget it, but it was a good ways into her property that there was a grave site there, and the town came and taped it off.
Rewind. The government just abruptly came onto her property and taped off an area and said, it's a public site.
A man in town claimed one of his relatives was there. And so the story is that he went to the town and complained about it. And so instead of them working this out so that he could go and look, they passed a law that allowed everyone to go and look. So you could drive over to the next property if you want and park your car, according to the town, on the road, enter her private property, walk over a watershed 300 yards, I think it's 300 yards, into her property to view these stones 7 days a week. And if Nick stopped you, she'd be fined $500 for every day she refused to allow the public to come in. We're not talking old Indian cemetery or a national battleground. We're just talking some random stones, and nobody knows if there is even a site there.
The idea that just anyone can come onto your property, not just a couple feet over the line, but some couple 100 yards in, that's pretty distressing.
So this was one of those moments where the government was effectively taking someone's private property, but not calling it what it was.
The government can say that you have to have the access on your property. It can do that, but it has to pay for it. It can't just declare a trail on your property.
And the city hadn't paid Rose. She didn't want to just let this go. On top of not really wanting her farm to be accessible to just anyone, anytime, she was worried about liability issues.
See, the town ordinance generally required that the person who owned the property had to also maintain it. So that called into question, well, is she going to be liable for anything that now happens in that space, which is theoretically now open to a lot more foot traffic? It was a broad ordinance that really had more questions than answers.
Rose knew she wanted to fight the government's actions. The government had passed the ordinance in 2012 and trespassed on her property in April 2013.
And here's where the real issue came up. Before anything else, Rose had to establish that this was really a taking under the Takings Clause.
To do that, you have to go to court. You have to bring a case and have a judge say, yes, this is a taking.
Going to court is costly, both in time and money, so it's a big undertaking. And when it comes to this Takings Clause, there's another barrier. Which court do you go to?
She went to state court. The state court said, we can't hear your case. She went to federal court. The federal court said, we can't hear your case. You should go on back to state court. Ping pong. She can't get anyone to tell her, is it or isn't not a taking for you to pass a law saying the public has access to my private property 7 days a week? Is that a taking or not? Well, we can't tell. You gotta go to state court. State court says, we can't tell. It's not ripe. It's not ready. Go to federal court. Williamson County says you gotta go to state court.
Williamson County. I mentioned it at the beginning. Cases are built on other cases, and Williamson County was a Supreme Court case that set a really bad precedent for cases like Rose's.
And in Williamson County, the court said there are a couple different factors that have to be present when somebody is saying that the government has enacted some regulation that is in effect a taking.
Beckett's Joe Davis again.
So the Williamson County court said, first, there has to be a final decision by the government that we can evaluate. And second, the landowner has to have exhausted state remedies before bringing a claim for a taking. And that is sought compensation from the state in a lawsuit. So filed a state court lawsuit that says, I need to be compensated for this taking that you've just done. And the idea here was to defer a little more to local authorities on the concept that, well, land use decisions are sort of quintessentially local. And so the federal courts shouldn't get involved until the state courts have had a bite at the apple. But it had some unintended consequences that, again, Williamson County said, before you can sue for a taking in federal court, you have to sue and seek compensation in state court. But it turns out that there's this other federal law that says that federal courts have to defer to the decisions of state courts. They have to give them full faith and credit. And so what would happen in practice is people would go sue in the state court like Williamson County told them to. And if they lost and then they tried to go to federal court, the federal court would kick the case out because it would have to defer to the decision of the state court. So what was happening is they were being put in a catch-22. They were being told, in order to have a good federal takings claim, you have to sue in state court. But if you sue in state court, you lose your federal claim altogether.
I did warn you that this was all kind of head spinning.
It really is. David explained it this way.
There's another rule that I'll call the no second bite at the apple rule. So when you file a lawsuit, you don't have a right to file another exactly the same lawsuit. Okay, you don't get a second bite at the apple. This is a common rule in law. You bring all your claims the first time and you litigate them. If you lose, you lose. And the reason for this, you don't get to go back and file the same lawsuit again to see if you win again, a different judge, right? And the reason is just for certainty and resource. So Williamson County said on the one hand, go to state court, then come back to federal court. But the no second bite at the apple rule says, go to state court, you can never go to federal court. So again, the bottom line from Williamson County is that although it wasn't intended to bar property owners from ever going to federal court, it had that effect.
What the decision in Williamson County did was an abrupt change in the way Americans can bring their constitutional claims to court. Historically, constitutional claims go to federal courts.
Everyone is theoretically supposed to have a right to bring a constitutional complaint in a federal court. The reason being that after the Civil War, Congress decided that state courts weren't reliable to protect civil rights, including property rights. And this had to do with the emancipated slaves, the former slaves, and the fear that the state courts were going to hometown. And so Congress created a right to go into federal court when you have a constitutional claim. So for over 100 years, people, if you have a free speech claim or unreasonable seizure, search and seizure claim, and you think you're not going to get a fair shake in state court, you can sue in federal court with a more neutral adjudicator. Okay, so now go back to Williamson County. In 1985 in Williamson County, the Supreme Court said, no, property owners, you're different. You can't go to a federal court. And so that stuck property owners in a state court system, which in the view of many, are really limited because some states are less protective of property rights than other states. So the bottom line was that property owners under Williamson County, they're the only ones when they have a takings case that can't get protection in a federal court. And over time, what this did is that it dissuaded people from even protecting their rights, because feel like you're going to lose in state court. You can't go to federal court. You just give up. You don't sue in the first place, or you try some other theory. Like instead of saying your property's been taken, you say, oh, your due process rights have been violated.
So David explained what this did over time is it dissuaded people from protecting their own rights. Because if they felt like they were just going to automatically lose in state court, and you can't go to federal court, it's just not even worth it.
Let me explain why it's so important, because sometimes when we talk about this issue, it seems sort of theoretical. Why does it matter, state court, federal court? I care about my rights. What are my rights? And what about where I can go? And it's important to remember, again, the Constitution and the Bill of Rights is just a piece of paper. It's just a piece of paper unless somebody enforces it. So you can talk all about what your constitutional rights are, but if you can't get into a court to get those rights recognized, it's just a piece of paper. And so Williamson County and the Nick case is a case about court access.
Court access is not something we focused on in other episodes, but it's an extremely important issue. We've said that going to court is costly. That alone presents an obstacle, sometimes an insurmountable one. Rosemary Nick took that burden on, only to find that the whole system was stacked against her anyway because of the Williamson County case from 1985.
Well, she lost in a federal trial court, federal district court, said, Williamson County, sorry, Miss Nick. Basically, I think there's a problem here, but I can't do anything about it because Williamson County says you're supposed to go to state court.
This is when David and PLF stepped in.
She was losing and running out of money, and to take on the government for any civil rights claim, property rights or anything as a private citizen is just astronomical how much it costs. The government has taxpayer-funded attorneys. They can say, so sue us. And so you as a citizen, you're paying for their attorneys essentially, and you got to hire your own attorney. Often what happens is after a year of litigation, property owners are running out of money and they're getting ready to give up. And that's one reason PLF exists and some other nonprofit Becket Fund. We exist to level the playing field so that individuals can continue, that have good cases, can continue to fight them and the government just doesn't wear them down because of money and they throw in the towel, and that does happen. So we found Rose after she started losing, and she was happy to have our help and wanted to continue fighting, and we thought her case was good and it was emblematic of what is happening to other people. She was getting the runaround. So she went to the Third Circuit and appealed, said, court, you should interpret Williamson County to let my case through. You give me an exception, basically. And the court said, no, Williamson County is Supreme Court law. We think this ordinance is extraordinary and suspect. They were really felt it was a problem, but we can't do anything about it. Sorry, you should have been in state court. So Nick kept on fighting, and we said, we should ask the Supreme Court to change this Williamson County barrier to court access. So we took it to the Supreme Court in 2018, and the court granted the case. That's their discretion to grant it. They don't have to. They granted the case to reconsider Williamson County court barrier to takings cases.
If you've listened to other episodes or follow Supreme Court cases, you'll know that there are briefs filed by both parties in a case, as well as briefs submitted by other individuals or organizations. These are amicus briefs, also called friend of the court briefs.
Becket submitted a friend of the court brief in the Nick case because we noticed a concerning trend that developed after Williamson County, and it affected religious liberty cases.
Williamson County was fundamentally a case about what it means for an unconstitutional taking to have occurred. But in the decades after the decision came down, sort of a strange thing started happening. Courts started picking up those principles from the Williamson County case that you have to go through the local land use authorities and go through all the processes that they offer, and started applying them to other types of claims, including claims under the Religious Land Use and Institutionalized Persons Act, called or RLUIPA for short.
RLUIPA is a sister bill to the Religious Freedom Restoration Act, or RFRA, which we've talked about in other episodes.
RLUIPA was a federal statute passed by Congress that was designed to fix discrimination against houses of worship in local zoning decisions. Houses of worship, like churches and synagogues and mosques, are sort of unpopular with local zoning authorities. Sometimes it's because of just pure hostility to religion, or maybe hostility to a specific religion. And we see that often in the case of Muslims who want to build mosques, or Orthodox Jews. And then sometimes it's from financial self-interest. I mean, houses of worship are tax exempt, and so they supply less property tax revenue to local governments. Of course, these are all very short-sighted reasons to oppose houses of worship coming into an area, because houses of worship are great for a community. They increase community cohesion. Congregations take care of the poor and the marginalized in communities. And so there's lots of reasons that Congress would have wanted to say, hey, local authorities need to stop discriminating against houses of worship and let them build. So courts started picking up the Williamson County principles and applying them in cases brought by houses of worship under RLUIPA, and saying, just like a person couldn't sue under the Takings Clause unless they satisfied the hoops that Williamson County said that they had to jump through, the same is true of people of churches and mosques and synagogues who are bringing claims under RLUIPA. And it was really out of place in this context. I mean, Williamson County was about what makes a taking. RLUIPA is not about takings. RLUIPA protects against discrimination, again, against substantial burdens being put on people of faith in their selection and building of houses of worship. And so it's a very different right that's being protected, and Williamson County was very much out of place.
If you recall, Joe explained that part of the Williamson County decision said that in order to bring a takings claim to federal court, you had to show that there was a final government decision for the federal court to evaluate.
Williamson County had been uprooted from its native soil of takings cases and planted in the way of unwary RLUIPA plaintiffs. And this really had some really bad effects on RLUIPA claims. Like we were talking about earlier, houses of worship are already unpopular for local zoning authorities, and this really just gave them another tool to use to discriminate against houses of worship who wanted to build in a particular area. So they could just drag out the process so long that the house of worship would maybe just give up, because often they're operating on shoestring budgets. They can't devote years just to getting the proper clearances in order to build in a particular place. You would see local zoning authorities that would say, sure, we've got this rule that would generally prohibit a church from operating in this particular spot, but we'll consider an application for an exception. You just have to attach, X, Y, and Z assessments, traffic assessments, environmental assessments, all these things that would cost tens of thousands of dollars to put together, to hire the professionals to prepare, lots of lawyer time and lots of time in order to just get the application in front of them. Or they would say, the local zoning boards would say, we'll have a hearing on whether we approve your building here. And then they would cancel the hearing and reschedule it for several months down, and then cancel it again and reschedule it again. Or they might, sometimes they would pass a zoning law that was clearly intended to keep out this particular religious group that was trying to build. And then they would say, well, we'd consider, they would tell a court later, we would consider an exception. They just had to ask for it in the right way. And therefore, you should dismiss under Williamson County. So in all these different ways, it was serving as a tool to keep RLUIPA claims even from being heard on their merits, just by making the process so burdensome on houses of worship that they would just give up.
What's ironic is that RLUIPA is meant to protect houses of worship against substantial burdens on their religious exercise. Yet here you have this process that is so time-intensive and so costly, it becomes this enormous burden. Any small house of worship, any little guy, is completely barred from pursuing their rights under the law.
The application of the Williamson County standards to RLUIPA cases has been a real problem. We're talking dozens of cases where that bad court precedent prevented our RLUIPA cases from ever being heard. This is what Becket's friend of the court brief explained in Rosemary Nick's case, which David argued.
I thought it was helpful because it helped show, we haven't talked about it very much, but this Williamson County don't go to federal court rule for takings claimants had metastasized and grown and become this monster that where it started out just, and I put just being in quotes, just being these takings claims, it grew to bar property owners from bringing RLUIPA claims or due process claims or property owners bringing equal protection claims. In other words, it started becoming more of a monster than it even was. And in the end, in its worst manifestations, it was a bar property owners from federal court rule, not just a bar takings victims rule. That's what it was originally. Does that make sense? So I thought it was helpful for the Becket Fund to show that it was just expanding and becoming this mean old dog swallowing every property owner claim out there, barring you equal access to justice.
So the Nick case went to the Supreme Court. David Bremer described the day of oral arguments, standing in front of the justices.
You're standing very close to them when you argue the case, and they're like in a half circle in front of you, and it's sort of like an oral interrogation more than anything else. You get questions very fast from every direction, and as soon as you answer one, someone else has a question. Well, I felt good about the case before I ever got there because I thought we were on the right side and because I was all prayed up, frankly. So I mean, you read tea leaves at oral arguments, but you look for clues and hints, and sometimes you count justices to see, well, how many seemed favorable, but that's a very risky thing to do because they don't always rule for you the way it sounds at the oral argument. They go back in their chambers and they spend 3 months or 4 months writing an opinion, and a lot can change in that time. So the confidence that I had was in the case. It's not, oral argument is a important ritual in lawyering, and it helps the justices to test your theory and your argument orally, but it's 20 minutes or 30 minutes. It doesn't have the effect of the briefs. Most cases are won because of the writing, the briefing. They can go back and read it in their time and think about it. So in an oral argument, you don't have confidence in your case because your oral argument. You have confidence in the case because what's already been put before them. The nature of the case, the briefing, and whether you think you're just on the right side or not. So I was confident for those reasons. An oral argument didn't change that.
And it kind of didn't, because in an unusual turn of events, the case had to be argued twice. How did this happen? Well, oral arguments were held on October 3rd, 2018. This was 3 days before Justice Kavanaugh was confirmed to the normally 9-justice court, which meant that only 8 justices heard the arguments in Nick.
For some reason, and most people speculated that the justices may have been in a 4-4 deadlock over the Nick decision, the court asked to rehear oral arguments. So David went back and re-argued the case on January 16, 2019. And then, as usual, the justices took a few months to issue their decision.
On June 21st, 2019, the decision was announced, 5-4 in favor of Rosemary Nick.
It overruled Williamson County and said Williamson County is no longer good law. If you have a government, you think the government's taking your private property without paying for it, you can go to a federal court, just like the next person that thinks their First Amendment free speech or religious liberties have been valued. You property are no less than they are when it comes to protection of your rights.
And Chief Justice Roberts wrote the opinion for the court. He used a sort of a colorful metaphor that really made this clear. He said, well, a bank robber could always give the loot back later after having robbed it, but that doesn't mean that he didn't rob the bank in the first place. And that analogy is sort of what's going on here.
To recap, this was a case about property rights start to finish. And yet, because of this decision, houses of worship won't need to jump through unnecessary hoops, and local governments won't be able to forever delay decisions when it comes to houses of worship. So as you can see, the implications of this property case spread even into religious liberty cases.
Which is why it's so essential to defend our rights from all sides.
So this situation illustrates how individual liberties are often connected, and that's so just because of the nature of the way the law works. Courts often take a principle that was articulated by a court in one scenario, and they draw analogies, and they apply it to a different type of case that they think is similar. And especially within the context of the Bill of Rights, which are all individual rights against the government, they sort of together protect the sphere of individual liberty against government infringement, whether it's the federal government or the state government. And so often you see principles that are stated in one case that migrate to other cases, even in other rights. And so it's important to figure out when that sort of analogy drawing is right and when it's wrong, and when it's wrong to cut back on it and protect the right that's at issue.
Thank you to David Bremer and Joe Davis for granting us interviews for this episode. Music in this episode courtesy of Blue Dot Sessions and Jay Tibbetts. Our theme music was composed by Eric McNerney. Becket is a nonprofit public interest law firm dedicated to defending religious freedom for all. Our clients have included Amish, Buddhists, Christians, Hindus, Jews, Muslims, Sikhs, and Zoroastrians. For more information on RFRA, our work, and Stream of Conscience, visit our website at becketlaw.org or follow us on social media.